Yes, Mr. Stewart.
Thank you, Lord. So I briefly summarised the heads of the submission I would be making this afternoon.
Yes.
Before going back to those, I do want to touch on the authorities. Before I do so, my learned friend makes the point that I can't point to a case on all fours with this one, to which I make the counterpoint, neither can he.
Indeed. And this is always said in each direction. And you say it's because his case is hopeless, and he says it's because it's unanswerable.
Precisely.
But you are agreed that there is no case.
There is no case directly on point. But in my submission, it is, I'm afraid, to be predictable, my lord. But I do say that it's because what's very unusual about this case, and why it seeks to go on my learned friend's case somewhere that the authorities simply haven't gone before, is that there is no case where a rule or a policy is relied upon where it is not capable, at least in theory, of being applicable to the individual claimant, or operative, or in action, or in some way relevant to them.
I began to write that down, but I'd like to write it down in full.
Yes,
there is no case where a rule or policy is relied on where
it cannot be said, at least in theory, to be in some way applicable to the claimant, or operative, or in action, or relevant to them on a continuing basis. And as I said submitted to the court before we rose, my learned friend puts his case firmly on clause 29.2, the 60-year normal retirement age. And by definition, that cannot be applied to anyone who has passed the age of 60, as Mr. Parr has. It's in the rear-view mirror.
Well, it's in the rear-view mirror at the time of issue of the claim, or within 3 months before.
It's in the rear-view mirrors after the accounting date after his 60th birthday.
Yes.
And in my submission, the authorities are all grasping at a slightly... Ultimately, we're concerned with what should be a very straightforward issue. Was the de-equitisation conduct extending over a period? That's the ultimate question we're concerned with here. But if one goes to the authorities, in my submission, they're reaching for a way of formulating the principle that for there to be a continuing act, a policy or rule must in some way continue to be operative, relevant, in action, at least in theory, to the claimant. So with that in mind, I hope I can fairly swiftly run through the authorities that we would rely upon. Southern Western Ambulance Service and King, recent decision of the President, Mr. Justice Chowdhury, was a case where there were a series of acts said to amount to a course of discrimination. The finding was that not all of them were in fact discrimination, and therefore the conduct extending over a period was not established.
Sorry, Mr. Stewart, you're just going a shade too fast.
I do apologise. This is page 169 in the authority. And Mr. Justice Chowdhury said at paragraph 21, Hendricks demonstrates that there are several ways in which conduct might be said to be conduct extending over a period, or as it's sometimes called, a continuing act. One example is where there's a policy, rule, or practice in place in accordance which there are separate acts of discriminatory treatment. Another example is where separate acts of discrimination are linked to one another and they are evidence of continuing discriminatory state of affairs, as opposed to being merely a series of unconnected and isolated acts. In both of these examples, the continuing act arises because of the link or connection between otherwise separate acts of discrimination. So there is a real sense there of there having to be some underlying conduct which keeps time from running. And then at paragraph 33, he says, in order to give rise to liability, the act complained of must be an act of discrimination where the complaint is about conduct extending over a period. The claimant will usually rely upon a series of acts over time. I refer to these for convenience as the constituent acts, each of which are connected with the other, either because they're instances of the application of a discriminatory policy, rule, or practice, or they're evidence of a continuing discriminatory state of affairs. However, if any of those constituent acts is found not to be an act of discrimination, then it cannot be part of the continuing act. The tribunal considers several constituent acts taking place over the space of a year and finds only the first to be discriminatory. It would not be open to conclude that it was nevertheless conduct extending over the year. Hold otherwise would be submits to render the time limit provisions meaningless. And then at 36, the passage my learned friend has already referred to, that there cannot be, reliance cannot be placed on some floating or overarching discriminatory state of affairs without that state of affairs being anchored by specific acts of discrimination occurring over time. And in my submission, it's precisely what is posited here is precisely the sort of floating discrimination which not only didn't but couldn't operate against Ms. Parr in the period concerned with that is posited. And in my submission, therefore, there really are two broad areas where conduct extending over a period is established. One is where there is a rule which is always there and can, as it were, rear its ugly head to discriminate against the claimant at some point in the future and remains relevant to their employment. Or one has what one might call the aggregated discrimination, where one has a series of events which are said to be evidence of an underlying policy. But neither of those applies here, even in theory. Next, I'd like to go briefly to back to Sugrin in the EAT, Mr. Justice Wood, which is tab 6 in the bundle.
We don't have tabs, it'll have to be page numbers.
Page 34, Lord. And it's another it's another formulation where the courts are grappling with this idea of how does the rule continue to bite. And this was a case of the grading. There was found to be no continuing act. But at page 39, letter D, Mr. Justice Wood said, in his characteristic way, thus, a continuing act should be approached as being a rule or regulatory scheme which, during its currency, continues to have a discriminatory effect on the ground of sex or race. I might add, against the claimant. So one has to find some sense where either in practice or in principle, this rule or scheme continues to bite against the individual claimant. And if we could next go to Ravenska, which is page...
And Mr. Ken would say that that's the formulation he succeeds.
Well, with respect, Lord, we would submit that plainly he does not. Because if the rule relied upon is Rule 20, is Clause 29.2. That ceased to have a discriminatory effect on Mr. Parr once the discretion had been exercised in the way it was.
Or you could take 29.2 and 29.4 together and say, in reality, the two rules or the two sub-rules together are the framework within which the normal retirement age. And you don't get to 29.4 without having 29.2 there in reality. Well, you wouldn't have any reason to agree it.
I have no difficulty with that, but that doesn't help Mr. Parr either, because if one reads them together as we submit one should, and it's really a discretion, a conversation one has at that point, where the decision is taken, as it was here, that the equity partnership should terminate, at that point, there is no longer, the retirement provisions are no longer operating against Mr. Parr. His equity partnership is dead. He will never get profits from subsequent transactions.
But there's not a distinct, separate dealing with the equity partnership. On this analysis, 29.2 and 29.4 are the method of fixing a retirement date, both its end point and the terms upon which employment up to that fixed retirement date is. And the de-equitization, whatever you call it, is a facet, Mr. Parr would say, of the rules fixing his retirement date.
Well, it's not a facet of the rules. It just happens to be the way that the discretion was exercised in this case. But the key point is, once his equity partnership has come to an end, that's it. So and this is why I make the point later on, and we'll come to this, that it's completely irrelevant from the point of view of this case whether the firm had decided simply to terminate or to terminate the equity partnership and re-engage on a fixed share partnership. In either case, the effect is exactly the same. He can't get profits from subsequent transactions. One can look at it this way. Had Clause 29 been abolished the day after Mr. Parr was de-equitized, it made no difference to him at all. It helped him one bit. And
the main point is he wasn't de-equitized, full stop. He had an agreement fixing the terms and conditions of fixing his retirement date, which included accepting terms and conditions governing equitization.
Yes, but you see, this is the thing. He makes no complaint about the terms themselves. His complaint, and I can take him back to the pleading, his complaint is about the de-equitization. And it didn't matter if he was paid a small salary, a big salary, it was for 2 years, for 5 years, it makes no difference at all to this case. Absolutely not. It's nothing to do with
when he retires at 62, he can bring a case saying, I've been discriminated against, I've been retired at age 62, and my measure of loss is the amount of money I would have earned if I hadn't been earning a lower salary for the last 2 years. He could do that, couldn't he?
Well, he could, at age, in my submission, at the age of 62, I mean, it's a hypothetical, but at the age of 62, if he applies for an extension.
No, he says, I've been discriminated against, I've been sacked at 62. And assuming he wins that, then the question is, what is his measure of loss? Will he be able to claim the 2 years when he was earning less for the 62-year age?
Not in my submission. No. Turning then to Ravenska, it's another dictum which just is reaching towards the sense of reality about continuing acts. At page 59, Lord Justice Brooke says, in these circumstances, this is 4 lines from the bottom of the second paragraph. In these circumstances, the courts have held that if an employer adopts a policy which means that a black employee or a female employee is inevitably barred from access to valuable benefits. That's a continuing act. And we do pray that in aid because that captures another aspect of the authorities, which is that there is an important difference between an inevitable and absolute rule, which we don't have in this case, and a discretion, which is what we're dealing with. And a discretion focuses on the particular decision.
I don't think you can have it both ways, Mr. Stephens. I mean, if you're you say that the complaint is of de-equitisation, that's pursuant to 29.2. I think your case would be the same if there was no discretion. If 29.2 were simply the normal retirement date shall be the 60th birthday, but then Mr. Parr and the firm had entered into a new contract under which he would be a salaried partner, you'd still be saying that he's out of time.
Yeah, absolutely, and he would be, but he's out of time for these purposes, for distinct reasons. The one is that the clause 29.2 is a one-off de-equitisation, and that's it. The second reason is that he cannot point to a continuing absolute rule, as in the example such as Calder, for example, because there is, in fact, no rule that over 60s can't be equity partners. It's just that he wasn't. I mean, I haven't taken to you, but if I could just briefly show you Mr. Gallagher's statement, which is in the supplemental bundle, just so that you see how it worked. The supplemental bundle at paragraph 28, he gives a number of examples, page 102 in the supplemental bundle, paragraph 28. He gives several examples: Michael Butler, Mike Tovey, Richard Moore, who continued to be equity partners after their 60th birthday because of their contribution to the firm. So there was no rule, and one can see that here. There was no rule that over 60s. There was a default position, which unfortunately for Mr. Parr was exercised against him. His equity partnership terminated, and he didn't bring a claim in time. I have copies of Tiagi, which I hope are more legible.
Oh, good. Thank you.
Now, again, it's right to say that this case is not on all fours with this one, because in that case, Mr. Tiagi was saying, in a period after his employment had terminated, that BBC World Service had a policy of not recruiting ethnic minority staff to a particular position, and he contended that so long as that policy continued on the authority of AMES and so on, he ought to be able to bring a claim. And so this is an important case in that it points out that the example posited in AMES cannot be pressed too far. Not too much weight can be put on it. It was a hypothetical, and if you took it too literally, it would have meant that he was in time. At paragraph 18, Lord Justice Brooke refers to Mr. Justice Brown Wilkinson's judgment in the Calder case, which in turn relies on on the Amy's case, and he makes the point that he doesn't, in my judgment, he says the relevant passage in Amy's refers to the potential of complaint available to employee in the school be denied access to opportunities for promotion. In the passage, Mr. Justice Van Wilkinson, which I've just cited, that will take the matter no further because there was no specific concentration on the particular issues now before us. So he's saying, it's not dealing with this situation. And then at 25, what's critical about that in my submission is that Lord Justice Brooke doesn't say that there's no conduct extending over a period because there's no longer any relationship. That's not the way he puts it. The way he puts it is to focus on whether it is inaction. And that's the wording he uses. Now, the example in this case is that there was no longer an employment relationship and there was no job on offer. But the general principle in my submission is sound, which is that if the rule cited cannot in any sense said to be inaction, then there cannot be said to be a continuing act.
I'll just ask the court, please, to read paragraph 25 insofar
Yes,
as it may have been a bit too small in the.
Yeah.
Will do.
And in particular,
Well, we'll read the whole passage. Same point I made earlier about the reported case always being easier than one is trying. Mr. Tiagi had not worked at the BBC for more than a year before he issued his claim.
yes, and so it was an unsurprising result. But in my submission, what Lord Justice Brooke is saying is that the discriminatory practice must be in action. In this case, it wasn't in action. He was no longer employed, and relevant vacancies were not on offer. In our case, it's not in action because Mr. Parr was de-equitised at past 60, and that clause was, so far as he was concerned, ancient history. The key question is it in action? Is it operative? Is it applicable? Is it relevant on an ongoing basis? Next, I'd like to go briefly to Okoro. Now, the facts of Okoro, as I mentioned...
Well, let's find it first. Can you give us
Yeah,
a clue?
I'm so sorry, my lord. Page 158.
Thank you.
So the facts of Okoro are set out at paragraph 8, and these were contract workers who were being sent by the employment agency. They were being sent to work at the site, and the site manager banned them, ex-hypothesized because they were black, and they were reassigned there, and they were turned away again. So there was a situation of a tripartite relationship: employment agency, building site, black workers. The employment agency was sending them to work. The site operatives were Taylor Woodrow banned them and sent them away. And the ban was ex-hypothesized ongoing. And my learned friend took you to some of this earlier, but the passage I wanted to refer to is paragraph 33 at page 167, where Lord Justice Pill says, Mr. Cooper relied on the approach of Lord Justice Brooke in Tiagi and BBC World Service where the selection process for a World Service post was claimed to be racially discriminatory. The application to the tribunal was made a year after the employment had ceased, but the claimant sought a ruling on the basis that the discriminatory policy would discriminate against him in the future if the employer offered a job. Lord Justice Brooke, with whom Lord Justice Longmore and Sir Christopher Slade agreed, rejected the argument, stating that the Act does not bite on a discriminatory practice which is not in action at all vis-à-vis a particular applicant if he's not employed by the employer at all. There is no ongoing relationship with which it can be said that the protection bites in relation to the claimants it was submitted. The subject matter of the complaint is no longer in action. Turning away the contract worker after more than 3 months would at most constitute an independent act of discrimination. And then at paragraph 35, he says that he substantially accepts that submission. So the question is, does it bite? Is it in action? And I come back to the point, in this case, once Mr. Parr's past his 60th birthday, his equity partnership comes to an end, the rule he complains of does not bite. It is not in action. It's irrelevant to him. Finally, I can deal on the authorities briefly with the Ekejiaku and British Institute of Technology. I go there merely to make the point that, again, if one strips away the authorities and the arguments, it comes back to the basics here. What is complained of in this case is a demotion. What is complained of is that when Mr. Parr went to see Mr. Gallagher and said, I want to stay an equity partner, Mr. Gallagher said, no, you can't. I'm demoting you to a salaried partner. And the tribunal, in terms, characterised that as a demotion. A demotion is, as Mr. Justice Sewell said in the Ekejiaku, a classic example of a plain example of a one-off act.
And 29.2 just gave the opportunity to bring it about.
Yes. And before I come to that's all I was going to say to the authorities. Safe to just make a couple of points about Selden. Selden isn't a case about time at all, as was acknowledged. But it's perhaps worth recalling Baroness Hale's comments in Selden about how age discrimination is different. And contracts of membership, employment, pension, and so on are full of age discriminatory rules. Many of them are justified. It's a different line of country to the starker age and sex discrimination, which some of the early authorities...
Race and sex. Starker race and sex
discrimination in some of the early authorities. In my submission, Selden doesn't greatly help, other than it's be noted that in that case, ultimately, the discriminatory rule was found to be justified and not unlawful in Selden. So the suggestion that somehow one's dealing with discrimination, which the respondent here is trying to sort of...
Well, it is differential treatment that has to be justified.
Exactly. But the point
it's not as bad as treating Welsh people badly, but it's pretty grim.
Well, in some ways, age discrimination, is unlike treating Welsh people badly, my lord, is incapable. It is capable of being a good thing because it's necessary for all sorts of social policy objectives that were outlined by Baroness Hale in Selden, and she's not advanced under any of the races. So, and I think it's just worth bearing in mind because the impact of holding any age-based rule to be continuously discriminatory whilst anyone remains in a relationship with the body that adumbrates it would be very far-reaching indeed. And I'll come to the more specifics of that in a moment. But returning to my three submissions then. So the first submission is we must focus on the act complained of in this case, as was said in Cast. And the act complained of in this case is a demotion, a de-equitisation. It was the decision to terminate Mr. Parr's equity partnership and demote him to a fixed share partner. And in my submission, once that had been done, that was it. And the policy in clause 29.2 simply ceased to have any relevance to Mr. Parr after that date. One can illustrate this with another example. Take a disability case. Say this is a disability discrimination case where a member of an LLP perhaps has cancer or is in a car crash. And there are very unfavourable terms as to sick leave, and they say that fortunately they take their time off, recover fully, completely fit, not disabled anymore. 10 years later, they say, when you didn't give me enhanced sick pay 10 years ago, you discriminated against me because I was disabled. I'm still here, the rule's still there, I'm in time. On my learned friend's case, they would be, even though they weren't even disabled anymore, because that's his simplistic formula. That can't be right. So we submit that focusing on the conduct complained of here, as it's set out in the claim, as it's set out in Mr. Parr's witness statement, as in any common sense it would be described, it's a one-off act with continuing consequences and not some kind of continuing application of clause 29.2. The second submission is that this was not a case in which there was a prohibition on over 60s being equity partners. That's clear on the face of clause 29. It's clear from Mr. Galler's evidence, which was accepted by the Employment Tribunal, and Mr. Parr himself accepted that there were equity partners over the age of 60. And in that regard, I would respectfully adopt the reasoning of the Employment Appeal Tribunal at paragraphs 45 to 46, which is pages 89 to 90 of the bundle. At letter G, at page 89, Mr. Gulick says, two important things happened after the 30th of April 2018, consequent upon the de-equitisation agreement. Firstly, the claimant remained a member of the LLP, but his status as a member changed from that of equity partner to an ordinary partner. Secondly, the future period of the claimant's membership was fixed at 2 years. The employment judge's reference to what happened as a demotion captures the essence of what occurred. It's clear the claimant viewed the change in status from equity partner to ordinary partner both undesirable and unwelcome. The de-equitisation agreement was itself a product of operation of clause 29. However, that provided for the norm to be retirement of all parties immediately after their 60th birthday. However, that was subject to a discretion on the part of the managing partner to disapply what would otherwise be the case, i.e. mandatory retirement. I accept Mr. Stilitz's submission that clause 29.4 is important because it provides an express discretion permitting equity partners to continue beyond what would be the normal retirement date. The evidence before the employment judge, which she accepted, was that the discretion had previously been exercised to permit equity partners to remain in the firm in that capacity after they reached what would have been their normal retirement age. This is not, therefore, a case in which there was a rule that no one could continue as an equity partner after reaching what would otherwise be their normal retirement age. There was a genuine discretion which had been exercised in different ways than other cases. the employment judge's findings, the matter was looked at on a case-by-case basis. So we respectfully adopt that and say, therefore, that the discretionary nature of the this matter was highly relevant. And thirdly, and finally, we make the point, which in some ways perhaps the most fundamental one analytically, which is that Mr. Parr's continued relationship was simply irrelevant to the discrimination he complains of. The judge at first instance found, correctly we submit at paragraph 23, which for your notice page 116 of the bundle, that had Mr. Parr's membership simply terminated on the 30th of April 2018, time would have run from that date. Now, this is where at paragraph 57 of our skeleton argument, we set out the three potential scenarios as to what might have happened. Scenario 1, MSR declines to exercise any discretion and partnership terminates. Scenario 2, equity partnership is terminated, but the discretion is exercised to engage him as a fixed share partner. Scenario 3, he continues as an equity partner. The key point is that from the point of view of the discrimination complained of in this case, scenarios 1 and 2 are completely indistinguishable. Both have exactly the same consequence. He's lost his equity partnership, he's lost any possibility of profit share from later transactions. And we say there is no principled basis for seeking to distinguish, as the employment judge did, between scenario 1 and scenario 2. The only difference between them is that in scenario 2, MSR acted more favourably in retaining Mr. Parr on a different and less advantageous basis. To put the point another way, we say that the fact that Mr. Parr continued to have a different relationship with MSR after his de-equitisation is entirely fortuitous and irrelevant in terms of the discrimination of which he complains. His ongoing status as a non-equity member had absolutely nothing to do with the losses of which he complains, which were directly consequential, as he says in his statement, on the decision to end his equity partnership. And again, we pray and aid the reasoning of the EAT on that, in particular paragraphs 47 and 48, pages 90 to 91, or 90 to 92 of the bundle. We'll not recite those, you'll have read them and no doubt can read them again. Finally then, I turn to the policy considerations that we submit strongly support the analysis which I've commended to your lordships and your ladyship, which is that if the appellant's approach were followed, it would have highly deleterious consequences for LLPs and partnerships which operate a normal retirement age, as many do, for good reason. In particular, it would entail that time would never run against the partner who'd been de-equitised, and it would leave him or her free to bring claims in respect of subsequent profit-generating events years after the decision which was alleged to have been discriminatory. Because on this approach, if the profitable transactions took place 5 years or 10 years after a de-equitisation, the claim would be in time so long as the firm maintained a normal retirement age and the partner remained with the firm. As Lord Justice Pill put it in a coro, the Employment Tribunal would be obliged to hear a complaint whenever brought, and the time limits would be rendered meaningless.
So you say it would act as an incentive to be ruthless and say, right, you're out tonight, goodbye.
Precisely, so my lord, and that is not an inter orum argument in the sense that it's extremely common as members of solicitors firms, accounting firms, all sorts of LLPs reach the later stages of their career, perhaps aren't sort of leading the business commercially in the way they once did, but want to remain engaged, and the firm may very much want to rely on their expertise and experience. And it's extremely common for them to become consultants, fixed share partners, and all the rest of it, and a good thing too. There would be a massive disincentive to doing that because if ever, years down the line, part of the business is sold, they could pop up and say, well, that's age discrimination. I want my 2.75 or 3.75 million pounds or whatever it is. And it would, in effect, bring careers to an end unnecessarily prematurely. So, whilst that's not in itself a construction argument in relation to section 123, it does mean that in this case, common sense chimes with the wording of the legislation and sound policy.
It doesn't help us to decide what the wording means, but you say if we decide what it means is what you say it means, we shouldn't be worried because that's good.
Yes, and perhaps in this...
It's a reality check after we've decided what we think the case means.
It is, and in my submission it gives some heft, if I can put it that way, to the various dicta that have been discussed, talking about the need for a policy to remain in action, operative, and so on, because the construction we contend for avoids these very artificial scenarios where long after an event, simply because my learned friend's sort of three-pronged formula applies, very stale claims can be brought by non-equity partners. So, my lords, my lady, unless there's anything else I can assist you with, those are submissions on behalf.
Can you just say whether you differ from Mr. Cohen's answer as to why the just and equitable point was never decided? It was, and we can see from the PT's judgment that it was in the agreed list of issues which the judge had to determine. She determined the point under appeal now in the claimant's favour and said, therefore, I don't have to decide just and equitable. Your side then appeals to the EAT. At what stage was it suggested on the claimant's side that the just and equitable point ought to be decided before the case?
I'll need to take instructions on that. I'm afraid we simply don't know offhand when that suggestion was made. I mean, I can't comment on the real, it would be speculation as to why the employment judge decided to found her decision solely on the conduct extending over a period. But it's right to say that the just and equitable matter was also argued.
Yes.
And that when her judgment came, she simply felt that that disposed of the issue and was sufficient unto the day. But I can't speculate as why she didn't make findings in the alternative. It was obviously a matter for her.
Did you resist it being decided before this appeal?
Yes, I understand that our position was once that had happened and we appealed this issue ought to be determined before matters went back to the Employment Tribunal, and the Employment Tribunal agreed with that.
So that was even before the case was heard in the EAT.
That I don't know. It was certainly before it's been heard here, but I don't know whether it was before it was heard in the EAT.
Right.
So
No, it's not determinative of the point of substance we have to decide, but for my part, I think it's very unfortunate. We are now 2 years and 3 months from the ET decision, and we're still only on preliminary point 1. Preliminary point 2 hasn't been decided, let alone the merits. And as Maynard Keynes said, in the long run, we're all dead. All right, thank you, Mr. Stevens. I don't think we have any other questions. Mr. Cohen.
Lord, I have 6 short points to make in reply. The first of them, just whilst it's fresh in everybody's mind, is to grapple with what's said to be the policy considerations. And there's always a short answer to a point of the kind my learned friend makes, which is don't incorporate discriminatory terms in your members' agreements. And in fact, if the outcome of this appeal is that you agree with Mr. Parr, then there is a disincentive to discriminate. And that's a good thing, not a bad thing. I don't suggest it really helps you to arrive at an answer in respect of this appeal, but since the point has been made, I'll simply counter it. But it's also right to say that the law has always recognised that where there is an act extending over a period or a contract term, or to quote the new legislation, conduct extending over a period, that matters might be tried a very long time after the events in question. That's the nature of the drafting of the legislation. If one takes Kapoor as a practical example, it is a term of the employee's contracts in Kapoor that they won't be credited with their prior service in the East African banks. Now that's classically a one-off act with continuing consequences, unless one can point to the underlying contractual term and say, well, that means that there's conduct extending over a period. Well, in that situation, one can well see that Barclays might have been facing a trial and liability 30 years after the event with massive financial consequences. But no one suggests that that's in some way wrong or undesirable. It's what the House of Lords found was the position in Kapoor. So it follows that the in terrorem point is not only wrong because there's a countervailing consideration, but in fact it doesn't on any analysis reflect the law as the House of Lords have said it is in Kapoor. So that's the first point to make. The second point to make is that my learned friend doesn't deal at all with the RRA or the SDA, not in his skeleton, not in his oral submissions. Now I could make a jury point and say that's because he finds it difficult, but I'll say something different about it. My Lord Justice Bean rightly says that there's not much academic rigour in either of us saying that we can't find authority that reflects the other's position, and I accept that. But what I can do is show you statutory language which operated up to 2010, which addresses the present situation, and on a plain reading of that language means that my argument is correct. And what that would indicate is that it's not a surprise not to find any authority dealing with this particular point directly, because at least up to 2010, the statute clearly provided for this situation. And it did so in terms that means one has to do no more than show the continuation of the relationship and the continued incorporation of the term, with no additional requirement for anything to be, just to quote those words that have now been bandied around a lot, inaction. So that is a critically important point. For my purposes, all I rely upon is the fact that my learned friend doesn't make the point to you that anything in the Equality Act change the meaning of the legislation, that the language may have been changed, but the meaning hasn't. And in those circumstances, what the 76 and 77 Acts said is critically important to this appeal. That's my point 2. My point 3 is this. There's been some suggestion that we were not complaining below about the contractual machinery. I simply say that's not correct. At all times in the Employment Tribunal, in the Appeal Tribunal, and here, our complaint has been about the continuation of the term, its incorporation in the LLP members agreement. We are squarely putting our case that way, and we always have. Point number 4. My learned friend says that the clause 29.2 can only apply once because you only reach 60 once. Now, on my case, that doesn't matter at all. That factual issue is irrelevant because providing the term continues to be incorporated in the members agreement and the members agreement continues to operate between the parties, that's enough. But in any event, factually, that's not correct because we know that the effect of an application of discretion under 29.4 may be, and indeed was the case here, that one's normal retirement age is extended. At the end of the extension, one goes back into 29.2, and at that stage either retirement is compulsory or there is some sort of further exercise of discretion under clause 29.4. So to say that 29.2 is factually a dead letter is not correct. It continues to have the potential for effect even after its first application, if I can put it that way. My point number 5 just comes back to the issue of there being, as my learned friend says, no case where a rule or policy has been found and it can't be at least said to be in theory in action or relevant on a continuing basis. Well, Kapoor is exactly that case. If we go back to Kapoor, I know we've looked at it already, but just to establish precisely what the facts were in Kapoor, page 19 of the authorities bundle. And it's probably helpful to look at bundle page 29, where Lord Griffiths at the top of that page begins to summarise the facts. And if my lords and my lady go, for example, to the second paragraph, the second, third and fifth applicants had all been employed by Barclays Bank DCO in Kenya and accepted employment with Barclays Bank in the United Kingdom upon terms that their service with Barclays Bank DCO in Kenya should not count towards their pension entitlement with Barclays Bank Limited. And the next paragraph makes the same point in respect of another respondent. Now, what that means is that there is a quintessentially one-off decision that is taken. You will not be credited with your previous service with an East African partner bank.
You're using shorthand, aren't you? It's not you will not be given a lump sum. It's rather when you come to retire, you will only be given a pension as though you'd started work in 1975 rather than 1965 or whatever it is.
It's a different but not unfair way of summarising it. But nonetheless, a decision is taken at that point in time that, let me use the word recognise perhaps,
yes,
that we will not recognise your prior service. Now, if that had been simply a decision and no more, it would plainly be a one-off act with continuing consequences. The continuing consequences being in the future you'll get less than you would otherwise get. The reason it's not that limited one-off act is because it's enshrined in the contract as a contractual term. And the effect of that means that whereas the employees in Kapoor in ordinary circumstances would only have had 3 months from the decision to complain, they've got 30 years, let's say, if that's how
that, the Act wasn't even in effect. So
yes, they have however long
yeah.
they could wait till they get to, let's not confuse it with retirement age, but wait till they get to their retirement age and bring a claim at that point in time. And the only thing that distinguishes their position from another employee who's told we will give you or we won't give you some form of benefit is that the decision is enshrined as a term of the contract. And there is no further application, nothing is in effect or in operation or whatever language one wants to use. Kapoor is a prime example of precisely the point that I make to this court on this appeal. So that's my 5th point. My 6th and my final point is to deal with the difference between an absolute rule and a discretion. My learned friend says, well, this is not a case where there was an absolute prohibition on over 60s being equity partners. Can I just perhaps posit an example just to test the difference between what he says is an absolute rule and a discretion? Absolute rule, no female employee can receive the same benefits as the male employee. So one has an LLP members agreement, the men get a car allowance, a mortgage allowance, the women can't have any of those things. An absolute rule, no ambiguity about that. Even my learned friend accepts that there's a term of a contract, a rule, whatever you want to call it, that continues. Now change those facts ever so slightly and make it a discretion. The provision says men get the car allowance, men get the mortgage allowance. And that's clause 1.1. Clause 1.2 says we have a discretion to decide whether we are going to pay that to women or not. Now, could it possibly be said that that is not a discriminatory term? Of course not. Because when one puts the men alongside the women and compares the rights that they have, the rights that the woman has are significantly less than the rights that the men have. The men get, the women are subject to a discretion whereby they might get or they might not get. No one would suggest that that's not a term which has discriminatory impact. And indeed, one has to keep in mind that for the purposes of the discrimination legislation, detriment is always viewed subjectively from the perspective of the person who is alleging they've been discriminated against. Of course, they can't hold a wholly unreasonable view about what's discriminatory, but it's viewed, according to the Supreme Court, from their perspective. Anybody who is subject to a discretionary right, where a man gets an absolute right, would plainly regard that as being discriminatory. So the fact that you have a contract term which provides for a discretionary right rather than an absolute right doesn't change the picture one bit. If that... I'm sorry.
Under your system, I was just thinking, I'm just working out the consequences of your case. If you had a rule, you could only get a mortgage if you were under 35, or you can only have a first purchase mortgage, which is likely to affect younger people. So you can only have a mortgage under 35. Somebody starts work at 25, they don't buy a house at all. Then when they're 55, they think, yeah, I'd like a house, but I can't get a mortgage now. Under your system, I'm not saying if it's right or wrong, I just want to know, can that person claim discrimination on the grounds that there's been a rule, it applied to me, I couldn't have a mortgage until 35. If it went, I might have a mortgage now.
They absolutely can. Their difficulty is they might have no remedy. Because if, in fact, they never had any intention of buying a house...
No, but if at 55 they decided to, you would say they can. That'd be... no, I think it works, your case, yes, I understand it.
Well,
because
yes.
you'd be saying you shouldn't have the 35 cap, it should be 55, yes.
Yes.
Or whatever, yeah.
Well, it would potentially work in those circumstances, yes. I mean, it depends on how you put your case,
Yeah.
but in theory...
But in principle, the rule dictates, for however long it applies, it dictates the ability to bring the claim.
Exactly that. The discretion here is a red herring. It detracts from what is going on. Because even if even if the LLP members' agreement had said, we have a discretionary right to do something to people of a particular age, we might not do it, but we might. And there was not the same discretionary power which applied to those of a different age group, there would still be a discriminatory term and there would still be the ability to complain about that term for so long as it was not abrogated. So that the discretion, if I can put it that way, is a distraction from the real issues in this appeal.
Mr. Cohn, can I just ask you about Kapoor, if we could just go back to
Yes.
Kapoor. Page 30 of the bundle of authorities, top of the page, Lord Griffiths summarises the two ways in which the applicants in that case put their claim. They said either terms of employment afforded to them were less favourable because previous service didn't count towards pension, or the way in which they were afforded access to benefits of the pension fund was less favourable than those afforded to European comparators, or they'd been subjected to a detriment in not receiving such favourable pension treatment. So that's the way they put their case.
Yes.
If you go right to the end of his speech, he comments right at the end that the Court of Appeal will write to approve two decisions of the EAT. And then he analyses the case in this way. Once the Act came into force, he'd probably be guilty of racial discrimination if he did not pay the same wages. If he continued to pay low wages to the coloured employees, I mean that's the language at the time, it would be a continuing act lasting throughout the period of the coloured employee's employment within the meaning of that. Man works not only for his current wage but also for his pension. To require him to work on less favourable terms as to pension is as much a continuing act as to require him to work for lower current wages. So it doesn't look as though Lord Griffiths analysed that case in the way that you were inviting us to analyse it.
Well, one has to remember, Your Ladyship, that what Lord Griffiths has been constrained to do is not rely upon limb A of 7, because the contract has come into force prior to the RRA being enacted. So what he does is rely upon 7B, and even though, as I've said to you, there is no act that continues to operate, that's a very infelicitous way of expressing it, but there is nothing going on because the decision has already been taken. There are only later consequences. Nonetheless, Lord Griffiths says, well, so what?
Well, I don't think that's quite how he analyses it, is it? He's saying this is a continuing act of discrimination.
Yes, he is.
Because you're not earning the same pension as you would if you were white.
Well, he doesn't.
I mean, I'm paraphrasing, but isn't that effectively what he's saying?
Well, he's certainly saying that you won't get the same pension, so that is detrimental. But the decision which has caused that to happen is one that has been made at the beginning of the employment and is enshrined in a contractual.
Well, that's how you analyse it, but the point I'm putting to you is a different one. It doesn't seem to me, and maybe I haven't read his speech carefully enough, that is the way that he analyses it.
Lord, my lady, I don't know that you can read just that sentence as carrying any particularly profound conclusion. Right. If one looked at Mr. Parr's situation, then he could also say that the consequence of a decision which had been taken earlier was that he was receiving a lower level of remuneration, would receive less benefit in the future. So he could put himself on all fours with the workers in Kapoor. But classically, the consequences of a discriminatory decision don't matter. And I don't think what Lord Griffiths can have been saying there is that because there were ongoing consequences, that meant there was an act extending over a period. If that was correct, then Kapoor would be heretical.
It wasn't the period of employment of that bank, part of which was counting and part of which was not counting. There'd been a switch, and the event was the refusal to credit on transfer.
Yes.
And you say that was a one-off act. it didn't affect the relationship ever between that bank, save that they didn't take it into account. And that's why you say, I think it's analogous, I think.
Yeah, yes. Just assume for a moment that in Kapoor one didn't have the underpinning of there being a contractual term. And it wouldn't matter if it was a term, a policy, a regime. Assume it was just a one-off decision. You know, Mrs. X sitting...
Which is a one-off transfer situation. It's not, I've worked for 20 years for this bank. They didn't credit me with a pension for 5 years because I was a woman. They only did for the last 25 years. But if you're talking about transferring in, then you will say it's more like a one-off effect because you've got a block of years, and the question is, do you take them into account for pensionable service?
Yes.
And you say those are the facts, and yet Kapoor won, so therefore you say...
Yes, if somebody sitting in an office at Barclays with no contractual underpinning had decided we are not going to credit you with your prior years of service in East Africa, then that would classically be a one-off decision. And what Lord Griffiths certainly isn't saying, because it would be heretical, is that because that has consequences which flow into the future, that means there is an act extending over a period. He can't be saying that because that's simply wrong. And earlier in his judgment, he's made the distinction between continuing consequences and continuing acts. What changes the picture in Kapoor is that there is an underlying contractual term, and that's the thing that means that the limitation period doesn't in any way begin to run. So that's why we say Kapoor is an obviously very valuable decision on these facts.
Do you accept that if the employees in Kapoor who presented their tribunal claims in 1988, if they had retired in 1978, they would be out of time because the decision to ignore their service in Kenya was a one-off act, and there's no continuing employment relationship? Or would you say, well, they're still only getting half the pension they should, so they can bring the claim any time until they die?
No, I certainly don't say that. What I say, coming back to a point I made earlier, I'm not saying that the only point I need to rely upon is the continued existence of a contractual term so that time does not start to run until the term is abrogated. The contract also needs to continue in force between employer and employee. So one has 3 months from abrogation of the term unless the employment ends earlier, in which case there is 3 months from the end of the employment. So the answer to my Lord's question is no, absolutely not. The pensioner can't, 10 years after the termination of employment, bring the claim. But 3 months from the termination of employment, which might be 40 years after the contractual term has been incorporated, the pensioner certainly can bring the claim.
And that's because the contract of employment is continuing, or was till less than 3 months earlier, as opposed to contract or maybe a trust relationship with the trustees of the pension fund, which is something else altogether.
Something else altogether, yes. And for which there are different discrimination provisions in the legislation in any event.
Right.
Lords, my lady, they were my 6 reply points, unless I can assist any further.
Thank you very much. You've both been of great assistance, as one would expect, and we will, of course, reserve our decision. We'll send it out in the usual way, in draft, not for re-argument, but for correction of typos and so forth. do that as soon as we can. Unlikely to be before Christmas.